because they've been working on it a while. We move around, we're like wanderers, but we're here now. But the other courtroom, they have big cameras, you can see everything. Hi, Mr. George, good morning. You were arrested for fleeing and eluding a police officer. I will appoint the public defender's office for you.
Judge, I have argument on the fleeing and eluding.
Go ahead.
Judge, there's nothing indicating lights and siren. At best, it would be resisting an officer without violence for running, but not for the felony. These are RID detectives.
State, I think she's correct. Where does it say?
Just give me a sec.
Where does it say that it doesn't mention they have their lights on?
No.
He noticed the marked police vehicle and an unmarked, I'm sorry, he noticed the marked and unmarked sped up and began fleeing. It doesn't say their blue lights are on, their siren is on, but they did flee after he stopped. You want $1 on that, or you just want,
Why don't we reset it for PCH?
you don't want to call the officer now?
No, we'll do it in the afternoon.
Okay, reset it for probable cause hearing in the afternoon. So I agree with Ms. He's allowed to bond out, yes. I agree with Ms. Corey. There was only probable cause for the resisting without. But he's not even charged with that. Even if he's not charged with the resisting without, I can still find PC for that. All right, we'll see you later, sir. Next, we have Louis De Leon. Page 9. Line them up, corrections. Good morning, Mr. De Leon. You were arrested for possession of a firearm, weapon, or ammunition by a convicted felon. I will appoint the public defender's office for you. There is probable cause for the charge. They found a gun in the center console and you're a convicted felon. Your bond is $7,500. Now, it's between the driver's seat. I'm sorry, that's where they found it. It was in plain view between the driver's seat to the right of the driver. I don't know why I thought it said center console. Anyway, it's a $7,500 bond. Have a nice day. Next is Luis Suarez, page 21.
Spanish, please.
Good morning, sir. Spanish. You were arrested for grand theft. I will appoint the public defender's office for you. Ms. Obando, you there? I don't see you or hear you. Is the interpreter there? I can't hear her. Guess we're still having technical difficulties. I have to pass it.
Señor, se le acusa de hurto mayor cuantía.
No, we hear you now. That's good. Tell him he's arrested for grand theft. I will appoint the public defender's office for you.
Se le acusa de hurto mayor cuantía y se está nombrando la Defensoría Pública para que lo represente.
All right, it's alleged he ran away from the store with a shopping cart full of merchandise valued at over $2,800.
Se alega de que usted se llevó un carrito de compras completo lleno de mercancía sin pagar.
So there's probable cause for the charge. You are ordered to stay away from the TJ Maxx store at 10001 West Flagler Street in Miami, Florida.
Se le acusa de mantenerse lejos y fuera de TJ Maxx ubicado en el 10001 West Flagler Street bajo orden judicial.
I'm setting a bond. He has an open petty theft case and the bond is $2,500.
La fianza es $2,500 y usted tiene otro caso abierto y pendiente de hurto menor cuantía.
Judge, Mr. Suarez indicates that he does have a place to stay. Would your honor consider any program for him?
Su señoría, el señor dice de que tiene un lugar a donde quedarse. ¿Consideraría usted algún tipo de programa?
I'm not giving him a program. He came in on an open bench warrant for $10,000 and he has an open that was the open petty theft case that he doesn't go to court on.
No le voy a dar ningún tipo de programa. Él vino acá con una orden de arresto y captura de $10,000 por el caso de hurto menor cuantía para el cual él no se presenta a los tribunales.
So he can post the bond or revisit the issue with the division judge.
Él puede pagar la fianza para salir o revisitar el asunto con el juez de división.
Okay, next we have Alberto Feizmer, page 22. Line them up, corrections. Any of you guys have any questions? I'll take questions. You're all playing on your phones. It's okay.
I'm sorry, Anna, who did you call?
I'd like Sudoku. I'm calling up Alberto Feizmer or
He
something.
refused court, Your Honor.
All right, let me review for probable cause. He's charged with second-degree arson. It looks like he lit somebody's Cadillac on fire. Question from the PDs. What's a signal 200? Those are career criminals, a signal. So based on the level, how severe it is, it's either 100, 200, 300, or 400. Okay, good question, because I didn't know the answer. One more question, then I got to go back. Yes, stand up. Don't be shy. He's in the corner. The suggested standard amount is 2,500. I think I lowered it to 1,000. The suggested amount is 2,500. It's up in my judgment what I want to set it at. There's suggested bond amounts that the Supreme Court gave out. That is for the jails. The judge can follow those, or they can go upward or downward. I can raise it. I can go lower. I can add house arrest. So unlike other states where some judges cannot even give a person bond, here in Florida, we have a lot of discretion on how to set a bond in order to protect the community and to ensure the defendant returns to court. Okay. Next we have is Daniel Perez. Good morning.
Buenos días, señor Pérez.
Sir, you were arrested for battery by a detainee on another detainee. I will appoint the public defender's office for you.
Se le acusa y fue arrestado por este nuevo cargo de agresión de un recluso hacia otro recluso. Le nombraré a la Defensoría Pública para que lo represente.
All right, there's probable cause for the charge. He pushed the victim, and then the victim.
For the slap, Judge, would you do?
Hay suficiente indicios de criminalidad para el cargo. Usted empujó a la víctima y luego la víctima. Señoría, ¿estaría usted dispuesto a?
No, he slapped the victim, then the victim pushes him.
Okay, le dio una bofetada a la víctima y luego la víctima le empujó.
Yeah, you want a lower bond? That's okay. State any objection?
La defensa está solicitando una fianza reducida. ¿Hay alguna objeción por parte de la fiscalía?
State any
That's fine.
objection? $1,000 bond. Have a good day.
$1,000 de fianza. Tenga un buen día.
That hearing had a little bit of everything. Judge Mindy S. Glazer presided over a docket that stretched from fleeing police to grand theft and even an arson charge, and she kept things moving with her usual clarity and a dash of humor. First up was Mr. George, arrested for fleeing and eluding. The defense pointed out the affidavit didn't mention lights or sirens, meaning at best it supported a resisting without violence charge. Judge Glazer agreed, noting she could still find probable cause for resisting, even if that wasn't the formal charge. She reset the case for a probable cause hearing in the afternoon, allowing him to bond out in the meantime. The exchange showed her steady hand, firm but open to defense arguments, and careful to keep the record clean. Next came Luis Del Leon, facing a charge of possession of a firearm by a convicted felon. The probable cause was straightforward, a gun found in plain view between the driver's seat and center console. Judge Glazer set bond at $7,500, moving quickly but making sure the facts were clear on the record. Then Luis Suarez appeared with the help of a Spanish interpreter, arrested for grand theft after allegedly fleeing a TJ Maxx with a cart full of merchandise. Judge Glazer found probable cause, imposed a stay-away order from the store, and set bond at $2,500, noting he also had an open petty theft case and a prior $10,000 bench warrant. The defense asked about diversion programs, but she refused, saying bluntly that his history showed he hadn't complied in the past. The docket turned heavier with Alberto Feizmer, accused of second-degree arson for allegedly setting a Cadillac on fire. When he refused to appear, Judge Glazer reviewed the paperwork herself and found probable cause. She explained to observers how suggested bond amounts from the Florida Supreme Court work, standard amounts that judges can adjust up or down depending on circumstances, and set bond at $1,000, lower than the usual schedule. It was a rare teaching moment in bond court, and she even fielded a question about Signal 200, explaining it meant a career criminal designation. Finally, Daniel Perez appeared, charged with battery by a detainee on another detainee after slapping another inmate, who then pushed back. The defense asked for a lower bond, and with no objection from the state, Judge Glazer set it at $1,000, wrapping the case efficiently. The overall atmosphere was brisk but balanced, defense attorneys making quick arguments, prosecutors weighing in as needed, and Judge Glazer keeping a steady pace while explaining the nuances of bond setting when appropriate. Defendants varied in demeanor, some polite, some absent, some confused, but all were treated with the same clear, firm explanations. It was bond court in classic form, efficient, precise, and peppered with small lessons about how the system works. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone,